Nicole. Thank you, Mayan.
Hi, everyone. Oh. Okay. All right. Hi, everyone. My name is Mayan Bouskila. I'm an attorney and founder of a New York-based law firm. I'm excited to be here today to talk with you all about the key ingredients to legal success in hospitality. It's amazing to be speaking to such a talented group of women hospitality entrepreneurs. There's always something exciting about creating and launching a new concept or idea, but to do something in the hospitality space is truly magical. I have such deep respect for entrepreneurs. Starting something new is really daunting. In fact, about a year and a half ago, I launched my own law firm in New York, focused on supporting all things legal for chefs, visionaries, and the hospitality industry. I took the leap of faith after more than a decade working at an international law firm advising on capital transactions, real estate, and corporate deals. So why did I go out on my own? Honestly, a lot of the reason was that my hospitality clients inspired me. Their tenacity and passion was such a source of strength and inspiration. I marveled at their entrepreneurial grit and their perpetual fire in their belly. They were there for me from the very beginning. So I think back to the first client who joined me on this journey. Taya and Peter, who are pictured in this slide, are a dynamic duo who launched a number of fantastic restaurants in the DC area called Immigrant Food. Their mission is to elevate and celebrate the contribution that immigrants make to America, told through an eclectic array of delicious food. They call it gastro advocacy. And as a new immigrant to America myself, having moved here about 6 years ago, it was so poetic that Taya and Peter were there to take a chance on me on the very first day I went out on my own. I also reminisce back to my childhood when I played sous chef in the kitchen with my grandmother. Every meal she prepared was a lesson in love, cooking, and business. She showed me the power that food had in bringing people together, sparking new friends and building community. As a mother of 12 children, she pretty much ran a cozy little restaurant in her home. Little did I know these culinary experiences early in my life would later provide me a framework to think about key legal ingredients to legal success in the hospitality world, from setting the table to hosting a dinner party, and even protecting my grandmother's secret spice blend. Proactively strategizing will improve your chances for an unforgettable meal and enduring business success. All right. So let's set the table with our finest and dive right in. Setting the table is laying a strong foundation for success. This starts with choosing the right corporate structure. Just like the careful placement of cutlery and glassware sets the tone for a dining experience, selecting the appropriate business entity sets the stage for your business's success. The type of entity you choose, whether it's a limited liability company, a C corporation, or an S corporation, will influence your operations, tax obligations, liability exposure, and even your ability to grow and attract investment. Okay, so let's begin by looking at the three most common types of business entities: C corporation, S corporation, and limited liability companies. I'll talk about each of the three in a few points. So C corporations are a popular choice for both companies that plan on seeking venture capital money and eventually going public. They stand on their own as legal entities. This means that the business, not the owners, are responsible for any debts. One thing to keep in mind is with C corporations, there is double taxation. Double taxation is the corporation pays taxes on the incomes it receives, and then the shareholders will also pay taxes on the distributions they receive. The benefits of a corporation are that you can have as many shareholders as you want, which is great if you're planning to grow and attract venture capital money. C corporations also will continue to run if the original owners decide to step away from the business. And they have a structure that investors are familiar with a board of director and strict corporate governance rules. This makes them a solid choice for businesses looking to expand. S corporation is actually a subtype of a corporation, and it's created through an IRS tax election. Unlike C Corps, S Corps avoid double taxation. What that means is that the profits and losses go directly to the shareholders, and so there's no tax at the corporate level. However, the limitations are that you can only have a limited number of shareholders, they can only issue one type of stock, and the shareholders must be a US citizen or resident. And lastly, I'll talk about limited liability companies. This is a popular choice, and especially in the hospitality industry. A majority of my clients I see form limited liability companies. The reason being is it's the best of both worlds. It has the liability protection of the corporation and the tax benefit of a partnership. Just like a corporation, your personal assets like your home, your personal bank accounts, cars are usually safe from business debts and lawsuits. For taxes, they're treated as what's called pass-through entities, meaning the profits and loss go directly onto your personal income without that extra layer of corporate taxes. And if your business grows and you decide you want to raise capital through a venture fund, you can actually choose to later convert to a C Corp or be taxed as an S corporation. They are also flexible in how they are managed and have fewer compliance requirements than corporations. Plus, you can have as many members as you want, making them great for different types of partnerships. So once you've chosen your business entity structure, the next decision would be which state to form your company in. Often, Delaware is a popular choice. The reason being is it's notorious for being a business-friendly environment. It has a well-regarded court system and established body of corporate law. If you plan to expand across state lines, Delaware can often be a smart choice. However, if your business is primarily local, forming in your home state is also advantageous because it avoids the need for what's called foreign qualification. This is the process by which your business has to obtain approval from the other state to do business in their state. All right, so we've set the table, we've chosen our entity structure, we've chosen to form in Delaware, so now let's host our dinner party. Like many hospitality entrepreneurs, we've gone ahead and chosen an LLC. We formed our entity in Delaware, and now it's time to decide whether you're going to go it solo or bring on business partners. For those choosing to go solo, your company would be considered a single-member LLC. This is a straightforward approach as the buck stops with you for all decisions. On the other hand, if you are launching a business with business partners, your company would be considered a multi-member LLC. Just a quick audience poll here. Raise your hand if you are a solo entrepreneur. And then what about if you have business partners? Yeah, so it looks like about 50-50. In my practice, the majority of clients I work with often go down the multi-member path. Even if they start as solos, they often bring in investors, even if that's silent investors. So as soon as you bring an investor into the company, you actually are considered a multi-member LLC. And all we would need to do in that case is simply redo your operating agreement. So for today, I'm going to talk about, I know a lot of people want to talk about partnerships, so I'm going to focus on the multi-member path. Okay, so the first document you need to prepare is a short 1 or 2 page document, and it's filed with the Secretary of State. It essentially includes the name of your LLC, the address, and a registered agent if you've appointed one. This is usually called the Certificate of Formation for LLCs or Articles of Organization for corporations. The second important document for an LLC is the operating agreement. For corporations, this is the bylaw. This is the equivalent of your partnership agreement. Think of it like hosting a dinner party. Just as you're going to plan the guest list, set the rules of the evening, the menu, the operating agreement sets the rules and guidelines for which you and your business partners will run the business. I'm going to focus on a couple of the most critical elements today to include in that partnership agreement. So the first one, when you're starting your business, it's important to think about the roles of your business partners. Do you want an active partner who's going to be in the trenches with you, or do you want a silent investor who's going to write the check and stay out of the kitchen? It's crucial to clearly define these roles in your operating agreement to avoid misunderstanding down the road. Make sure you map out who does what and whether they have a say in key business decisions. Next, think about whether you'll allow these partners to sell their share in the business at a later stage. Just as you don't want uninvited guests showing up to your dinner party, you need to control who can join and leave the corporation. This can be achieved by placing restrictions on transferring of ownership in the operating agreement. My grandmother used to say you should never discuss money at the table. However, she also said you should know when to break the rules, so let's talk money. Profit is the lifeblood of any successful business, but in the hospitality world, we sometimes aren't as clear as we should be about who gets paid and when. In particular, also making sure that we get paid ourselves. A good operating agreement is going to spell out how profits are shared. It will spell out how much of those profits you're going to reinvest in the business and when payouts happen. It also needs to address who gets paid first. This is known as a waterfall distribution, often benefiting those silent investors who helped you get started. They may have stayed out of the kitchen at the start, but they generally want their money back first. The beauty is that you can craft a waterfall distribution that both rewards those silent investors by giving them a portion of the profits first and also pay yourself. Unfortunately, disputes are bound to happen as you build your business with your business partners. Including a dispute resolution clause in your operating agreement is like having a plan for when things go wrong. This can be as simple as agreeing to talk things out with the help of a third-party mediator, or as formal as binding arbitration. It's like having a system in place to quickly and fairly resolve any issues among staff in a well-run restaurant. And don't forget, these provisions must align with state laws to be enforceable. The next two topics are incredibly important as you launch your business. The hospitality space is particularly challenging, as most of you are aware. It has modest margins, fierce competition, and labor shortages. The last thing you need is an unresolved dispute with a business partner that boils into them running off and enabling a copycat business. So how do we ensure this doesn't happen? We have two tools at our disposal. The first tool to protect your business is to include a confidentiality clause in your partnership agreement. This is key to keeping your business's sensitive information safe. For example, your business plans, your trade secrets, recipes, anything of that nature. It ensures your business partners must keep this information private even after they leave, even if you decide to split and they leave the corporation. These protections often extend after they leave, and they help safeguard your business's valuable assets in the long term. But you might want to take this a step further. A confidentiality agreement stops your partners from sharing secrets, but it doesn't prevent them from using what they've learned to start a competing business or go work for a competitor. That's where a non-compete clause comes in handy. A non-compete clause can stop members from engaging in competing businesses within a specific area and time after they leave the company. These restrictions have to be reasonable to hold up in court. Also, some states like California forbid them. However, there was a ruling in Texas that actually allows them recently. They are a hot topic right now, with different states taking different approaches as to whether they're going to be legally enforceable or not. However, for the moment, they're governed by state law, so there's something to consider. So these are just a few of the key points to consider when drafting your partnership agreement. There is a lot more meat to an operating agreement, and if you're interested in exploring this further, you'll find a link in this handout that was passed around at the start over on the bottom page. I've actually included on my website 3 checklists to help you form an LLC. There's a checklist of things that you can discuss with your business partner before going into business and what to include in your operating agreement. And there's also a checklist on how to trademark. So you've formed your LLC, you put together an operating agreement, and now it's time to create a trademark strategy. Okay. So when I think about trademarks, my mind wanders back to my grandmother's secret spice blend called Raza Hanut. This North African spice blend translates to head of the shop. It signifies a top-quality mixture of spices that represent the best offerings of a chef. This aromatic blend includes a combination of cinnamon, cardamom, turmeric, pepper, as well as some mysterious ingredients she would never share with us. My grandmother would never tell anyone exactly what went into her seasoning for fear that someone would copy her blend. But everyone knew her blend was the best in Casablanca. Fortunately, nowadays, we have trademarks to protect someone's brand from imposters. So she may have shared the secret nowadays. Okay, so what exactly is a trademark? Simply put, it's a symbol, word, phrase, or logo that sets your goods or services apart from others. For example, going to that first client I spoke about, think about Immigrant Food. They have a trademark for gastro advocacy. It's instantly recognizable as a restaurant that advocates for new arrivals to America. It evokes a particular brand story and sets their restaurant's mission apart from others. Trademarks are protected by law both in the US and abroad, giving you exclusive rights to use them so no one else can confuse or mislead your customers. Trademarks are the IP workhorse of the hospitality world. They help your brand stand out and become one of the most valuable assets of your business. To illustrate, imagine you're at LaGuardia Airport in New York with a few hours to kill. You wander around the terminal and suddenly there's a food station featuring your signature dish, bottles of your branded olive oil, and even a cookbook with a life-sized cutout of your smiling face. This isn't just a dream, it's the power of a well-protected brand. Just ask Einat Admoni, chef-owner of Balabusta and James Beard Woman in Leadership alumna, who made this dream a reality thanks to her culinary genius and strong trademark. So how do we make this dream come true for you? First, before you fall in love with a brand name or logo, make sure it's defensible. What does that mean? Start with what's called a knockout search through the United States Patent and Trademark Office to check if your trademark is available. This can avoid infringement lawsuits down the track. Once your search is clear, the next step is to file an application with the USPTO. This process can be long and sometimes tricky, involving a few rounds of back and forth with the USPTO. But if all goes well, your mark will be registered. Registration means that you have been granted exclusive legal rights to use that particular mark, preventing others from being able to use the same mark or confusing your customers. Even after registration, your work isn't done. You need to be diligent about maintaining your trademark. This means you need to keep your registration active by regularly filing required documents, such as a renewal form and proof of continued use. This generally has to happen every 5 years. A strong trademark strategy balances protecting your brand and practical decision-making. Not every potential infringement requires action. Many of my clients are now exploring new opportunities to expand their brands, like bottling their signature cocktail mixes or packaging their secret spices. These consumer packaged goods ventures have become more common for the chef community, which is frankly a silver lining of the otherwise awful COVID-19 pandemic. But to pursue these exciting paths, you need a solid trademark and intellectual property strategy. Protecting your brand identity, building customer loyalty, and securing market exclusivity will set you up for long-term success. So, we've set the table with a strong corporate structure. We hosted a fabulous dinner party and drafted a well-drafted operating agreement, and we protected our secret spice with an intellectual property strategy. These are the key ingredients that will result in a memorable experience for our guests and the key ingredients that will lead to legal success in your hospitality venture. You all know this. The hospitality isn't just about serving foods and drinks. It's about creating connections, telling stories, and building a brand that resonates with your customers. By taking care of these legal details from the outset, you can safeguard your dreams and ensure your venture not only survives, but thrives. And thank you for listening, and I thought I'd now open the floor for questions. Yeah.
Actually, just a comment. What you just did in like 15 minutes is freaking phenomenal.
Thank you. Thank you.
Second question is, can I repost your little brochure on social media and give you credit for it? Because I think so many entrepreneurs, like it's a very clear visual way to like at least get them thinking for those things.
Yeah, of course. Thank you. Thank you so much. Thank you. Yep.
We really struggled with like our signature products and then being advised about it's not really worth trademarking because food is so hard. Like a recipe, like the
anything is tweaked to, like, now it's no longer a trademark thing, or you can't prove it or something. So do you have any advice on, like, ours is a donut thing, and they were like, well, if somebody changed one topping on one donut,
Yeah.
doesn't copy you. So we just really struggle with that.
Yeah, no, that's a great point. So recipes, you can't trademark recipes, but what you could do is if there's a signature donut that has a name to it, you could trademark that name in class 43, which is the class for food and beverage. So that way other people can't copy, that signature donut, and hopefully you've kept that secret recipe with your confidentiality provision.
Thank you.
Yeah.
Sort of a follow-up to that. So my understanding is, yes, you cannot trademark a recipe, but it can be classified as a trade secret. So do you have specific advice around how to make trade secrets? I mean, I know you can have an NDA, but those aren't really super enforceable. But what are some of the ways that you can sort of defend yourself with showing your case with these trade secrets?
Yeah, so just a follow-up question. Is that like an employee who works with you that then has access to that information? Okay. Yeah, the way to go about that is to include a confidentiality clause in their employment agreement. So, I mean, often we don't have employment agreements, but we have offer letters. So in those offer letters, to have an annexure, which is actually a confidentiality and assignment document, because firstly, you want them not to be able to use whatever it is they learned while working with you. But secondly, you don't want them to claim that that's actually their intellectual property. So that document states that they are assigning anything they create while under your employment is actually yours, and they have to assign that back to you if there was ever a legal dispute. And those documents are enforceable. Yeah.
Is there like a boilerplate version of what you're talking about, or are those typically crafted?
There is, I'd be happy to, if you email me, send you a boilerplate version. Yeah.
So let me get this right. I own Coca-Cola, a trademark Coca-Cola.
Yep.
I have a scientist that created Coke Zero. That is a trade secret with the scientists that they created Coke Zero.
Yeah.
But I cannot trademark that recipe. I can only trademark it.
So Coca-Cola is actually different. Coca-Cola, you can't trademark the recipe, but Coca-Cola can get patent rights over the recipe because it's a secret blend that has never been released. No one knows what goes into it. But that is going down the patent path, which is something that you can't do for regular recipes, because the whole idea is that someone could change one ingredient and then make it theirs. So it's to avoid everyone trying to trademark their recipe. But you can trademark the name. So Coca-Cola has trademarked their name, Coca-Cola, and then they can also have protections around their secret recipe. That is their Coca-Cola blend.
Through a patent.
Yeah.
But mere mortals cannot do that.
Unless you create the next Coca-Cola.
But I mean, like, when does your business get to the point where you can patent it?
So patent is a really highly specialized area of law, and it's actually something, I don't do patent work, I only do trademark work. So essentially you would need to speak with a patent lawyer, but it's when you have a recipe like, or Pepsi, Coca-Cola, there's...
You know those fancy strawberries in New York that they only grow hydroponically?
Yeah.
Can you patent, is that patent?
I mean, obviously it's worth having a conversation with a patent lawyer. My guess is, maybe actually, but it's worth having a conversation with a patent lawyer on that. Yeah.
So, recently, DC Department of Small Businesses did a thing with the patent office where you could, as a small business, consult with someone from the patent office and just sort of pick their brains about whatever. And we availed ourselves of that a couple weeks ago and talked with this woman, and she mentioned that we might want to look into, like, going back at our trademarks and looking at the classes and reevaluating, because
There is, yeah, class 35.
Talk a little bit more about classes and what is the due diligence to go back through, or in the future, go back through, like how often should this be reviewed and looked at, and like how would you structure classes?
Yeah, great question. So on the USPTO's website and in the trademark checklist that is on my website, I give the link for classes. So there is a list of international classes. E-commerce is 35, restaurant, food and beverage is 43. And when you actually file your trademark application, you need to choose your class. Every 5 years, when you're filing that renewal report to keep your trademark, because if you don't file that renewal report, you'll actually lose your trademark. You have to provide what's called a specimen, which shows continued proof of use in that class. So if you're no longer using that word, logo, mark in that class, the USPTO is actually not going to renew your trademark. So you're forced to do it every 5 years. Does that answer your question?
Say I'm class for beverages.
Yep.
First year, and then I come out with a t-shirt
Yep.
the next year. Can I submit to have that patent for that class that second year?
Yeah, so you would just have to file a new trademark application for that word mark in that class. And then when you actually put through your application, there's a section where you would note where you are the owner of this other mark, just to avoid them. Because what's going to happen is when the USPTO gets the trademark application, your other trademark is going to get flagged as confusingly similar. And so you're essentially letting them know, like, hey, I'm the owner of that mark, so don't reject it for being confusingly similar with my own mark. But yeah, you can keep filing new applications as you expand your brand offerings. Yeah.
You mentioned, throw it on the wheel, you mentioned about the non-compete clauses or agreement.
Yep.
Can you make an agreement while they're still your partner?
As in after the fact?
Yeah, like if they cannot go and compete like certain area for a certain time.
Yes, however, I guess the issue you run into if you don't do it at the start is you lose bargaining power because they may not want to sign a non-compete after the fact. Yeah.
Because you said when they leave, and normally that's the norm.
Yeah.
But
Oh, while they're in, yeah, of course. So the non-compete should apply, the non-compete should apply like during the employment, because you don't want them actually setting up or working for a competitor while they're employed with you, but it can also extend for a period of time after their employment. That has to be narrow in time, so usually 1, 2, 3 years tops, and it also has to be narrow in the geography. So if you said, the whole of the world, it's unlikely that that's going to be enforceable, but if you say, a radius of 20 miles from your location, that is more likely to be enforceable. Yeah. Yep.
Following up to the question, what are your thoughts on the rule that just passed in spring this year regarding non-compete and how FTC is banned for them to, they say, to open the market to other companies?
Yeah, they banned it for that reason and also worker mobility. So that ban has received a lot of legal challenges. Essentially, at the moment, it's still governed by state law. So each state, for example, Texas appealed the decision and successfully it is allowed in Texas. However, California, it is not allowed. So you still would defer to state rules as to whether it's enforceable or not. Yep.
How consistent do you have to be in enforcing your trademark? I've heard that if you can't pick and choose, if someone violates it, you have to enforce it. Otherwise, you can kind of lose your trademark in the future.
So I think it's probably a nuanced answer, and I think each lawyer you ask is going to have a different response. So. Okay, yeah. So I'm personally of the belief that you can't to spend time and money trying to enforce every infringement is going to be exhausting. So I do think you need to kind of pick and choose. It doesn't mean, I don't believe that it means that your original trademark is unenforceable, because once the USPTO grants you that trademark, you have that legal right. That can't be taken away because you didn't issue a cease and desist. Yeah, exactly. And then the other thing to do is, so essentially, like, if you wanted to, the first thing you would do is issue a cease and desist to whoever that person is. And then you may want to enter into a coexistence agreement. So you can still own a trademark, but allow someone else to use that same logo, word mark in their area, because you feel that the two are not confusingly similar, and you're happy for them to do their thing, in California, and you'll do your thing in Texas. Yep.
And that's a great segue into international trademarks and China. Is it worth it? Is it not?
So I only practice trademark law within the USPTO, because within United States, sorry, because you have to be, and Australia, because I'm barred in Australia, but because you have to be barred in the country that you practice trademark law. I don't practice in China. I work with another law firm who engages counsel around the world, and I actually don't know, it came up the other day, a client was looking to trademark in China. Basically what we got told that we couldn't trademark that mark in China. So I don't know that China is a country that allows many trademarks to go through. Yeah. Yep.
I have a follow-up with trademarks, but in the U.S. I know that you can file a declaration of contestability after 5 years. If you do that, do you still have to continue to refile every 5 years on perpetuity, even if you do that, or is that kind of negate the need to keep refiling?
Yeah, so there's a declaration that you file as well at 10 years. At that 10-year mark, when you file that declaration, after that, you only have to renew every 10 years. Yeah. Yep.
I just want to make a comment though, that if you do have a product or you do have your name and you do trademark it and someone else does come into your space, you should vigorously defend it if that's the last thing you have, because there are bigger competitors, there are bigger house competitors that have a lot more money that will think that you're so small that you're too dumb to know any better and won't defend it. We went through that. We have a national competitor that copied something that I had trademarked and protected 10 years ago, and they thought we were so small and weren't going to pay attention and weren't going to fight back. And we went after them, and we were able to get our name back.
Yeah.
That we created. So don't underestimate the power that you have as a single person. Yes, attorneys cost money, but they are your best friend, and they will protect your ass when you need it. You have not worked as hard to get as far as you are to let someone else take that away.
Yeah, no, that's a great point. And one low-cost method to defend your mark is the cease and desist letter. Just starting with sending that letter can scare people away enough to go change it. It's if they don't listen to the cease and desist letter, then yeah, it's definitely advisable to get a lawyer involved and see what the next steps are. Yep.
So, this kind of listens to what everybody said. I do tamales, I do fusion tamales, and I trademarked it back in 2020. And so I'm starting to notice a trend that a lot of people are starting to duplicate what I'm doing. And I know the original thing is you add one ingredient to it and it's no longer there. But I have trademarked the cowboy tamale, the oxtail tamale. And I'm seeing people popping up with it. And then I have my lawyer, the customer, does you need to sue him, you need to sue him. It's can I really sue them for the cowboy tamale? And even though it is trademarked with black girl tamales?
Yeah, so I think we all, Momofuku recently, he's suing everyone for chili crunch. Yeah. So, I think that it's worth the conversation with your lawyer, and your lawyer can advise you on the next steps. Whether you will win the case, I mean, that's up to a judge to decide. And that's where you get into the gray area of law, where it does become subjective, because the way I interpret a rule can be different to, you know, the person next to me interpreting that same rule. Yep.
Well, I actually have a question for you. So you were able to trademark, that's definitely a recipe, right? Or is it trademarking like as an item?
Trademark as an item. So I had to list all of my flavors, when I trademarked it. I had to list all of my flavors. Now, I've added flavors past the fact, I'm okay with flavors. That California lemon, that's started with you. See other people with it. You know, it is one of the questions, like, I'm really super, I've always been told the recipes, like, a lot of restaurant, when I was a restaurant chef, you know, they'll have to sign an NDA, it's like, okay, if I change it to 23, that's my recipe, you know. So that's, I didn't have to do the actual recipe because of that, but I did have to list the names of like all my flavors of the tamale. Like I said, now that I've seen just the trend, and it's like, okay, I appreciate that I'm a trendsetter. For that, you know, with that being a thing.
That's good to know. I didn't know, because I have things like that too, but I actually thought they were not trademarked. Yeah, so that's good to know that that's true. I have a different question though. So I'm starting a CPG, but I'm doing it under a different LLC
Yep.
than my restaurant. And so I'm working with someone that I would like to, you know, bring on to long term to the business, and trying to decide how to, in this making out of your space, the best way to form legally that partnership. And like, it's not that I don't want to make him a partner per se, but I do want him to have like some equity.
Yep. Yeah. Yeah. No, that's a great point. So,
The best way to determine, and I don't know if anyone else can speak to this, the value of the equity, how much do I give, and how do I determine the value just off the top of my head? Oh, it should be 5% or 20%, or, you know.
yeah, so currently I assume the LLC is wholly owned by you. And then when you formed the LLC, did you prepare an operating agreement? Okay, so yeah, then essentially what you would need to do is you would need to amend and restate that operating agreement. And there are two ways that business owners provide equity to their employees. One is called profit interest units. So essentially you would create, you know, Class A members, Class B members, Class C members. Class A members are the founders. Class B members would be your investors, your strategic advisors, and then Class C members is allotted for employees, and it's called profit interest units. So you would have them sign a profit interest agreement, which provides them with a certain amount of equity. But what it means is that equity that you're giving them will vest over a certain period of time. So usually 4 or 5 years, you would decide on the amount of equity. Usually it's like around 5%, which vest over, 1% each year. And then you would also need to decide is when they leave, are you going to claw that equity back, or are you going to, do they get to keep it? So that's like the third thing to think about. And that can all be done with amending and restating your operating agreement, and then creating this third class of profit interest units. Because the reason people create profit interest units is to, that way they don't have like voting rights, they can't sell those shares, so you keep like tight control over them not being able to like be a key decision maker in the actual operation of your business. Yeah, yep.
So just to clarify, a profit interest unit is, it would be a member of the LLC?
Yeah, so essentially the reason it's set up is they would essentially share in the distributions of the profits. but they wouldn't have the voting rights, and they wouldn't be able to assign those interests. Generally, a lot of business owners will claw it back if they leave. Some business owners will structure it two ways, that if they are terminated for cause, then they'll claw it back, but if you decide to part amicably and on good terms, they'll let them keep those profit interest units after they leave. Yeah. It's specific to LLCs. So with corporations, you're governed by, with S Corps, you actually can only have one. That's one of the limitations of an S Corp. You can only have one share type, so you would actually be giving them equity. Yeah. Yeah.
You're an LLC filing as an S corp.
You're okay. No, because when you are, because you're electing to get taxed only as an S Corp. I would need to look into that. But if you email me, I'll look into it and I can get back to you. Yeah. Yep.
We just opened our second outlet, it's a separate LLC, we're in California.
Yeah.
And starting to think about the long-term structure, do you recommend having a restaurant group LLC that owns all of the ones underneath?
Yeah, that's a great question. So creating a holding company depends on how each business is set up. So if there are a couple ways of doing this. Some people want to keep each business separate because they have different investors and they don't actually want the investors to share in the success of all the operations. However, your brand becomes more valuable if you have a holding company and that holding company wholly owns each of your locations. Now that holding company is going to become a lot more valuable. However, it means, are you going to decide to if you bring in silent investors, are they going to come in at the holding company level, which is probably what they want? Or you can have those single operations, partly owned by the holding company and then partly owned by the investors. But yeah, holding companies are a great idea. If you know from the outset that you're forming and you want to set up 20 operations, it's generally best to just set up that holding company and that first subsidiary from the start. If you don't do it that way, you then need to roll up the company at a later stage, which can be done. It's just a legal process and a lot of paperwork. Yeah.
But if you are currently an S corp and you're considering expanding into other locations, do you have the ability to do LLCs and a holding company, or how would you structure that?
Yeah, so you can have your holding company be a corporation and then wholly own LLCs. Yep, that can be done. Yep.
Going back to the equity piece, would the profit interest units be similar to phantom stock plan? Is that the same? I'm asking because I have that with the director of operations who's got 10%, but invests over several years.
It's a similar concept, and the reason I assume the accountant suggested phantom stock is for taxation reasons. It would have been beneficial for your employee. They're all similar concepts. The profit interest unit, phantom stock, they're all similar concepts to help tax structuring. Yeah.
You said there were two ways to do it. So profit interest units as one, or what was the other?
Actually give equity. Yeah. So you could still create the different classes of memberships. And so you would have Class A members, Class B members. Class A members would get Class A units. Class B members would get Class B units. And for those Class B units, you would just restrict their decision rights in your operating agreement. So you would basically say that Class B members can only vote on, and whatever it is that you want to allow them to have a decision-making right. Okay.
Just because you're giving equity
No, because the beauty of a corporation is that there's no personal liability. I mean, not to get into it, but the court does have the option to pierce through a corporate veil. I mean, that's a whole nother, we need like 5 hours for that. But generally speaking, corporations, no personal liability. That is why people want to set up corporations or limited liability companies. And then in your operating agreement or your bylaws, generally there's an indemnification provision that some companies include, which basically says that the company will indemnify each of the shareholders from any personal liability. So if for some reason they're able to pierce through that corporate veil, the company's going to be the one covering the costs. Okay, any other, yep.
Is there a point where a chef should give the trademark the name instead of just the brand of the restaurant or the product?
Yeah, so trademarking your name, the trademark office will not always approve it. You basically have to be, I'm just trying to think of, Martha Stewart is a great example. Yeah, you have to be a public figure. So they would do like Google searches and things like that. So that not everyone can trademark their name. And then if you are trademarking your name, there are additional steps and documents that you have to sign when you file your trademark. But yeah, it is possible, and there are a lot of chefs that do it. It just should be done at a certain point, and that's something that I definitely would recommend speaking with a trademark attorney, like as to your particular situation. Okay. Any other questions?
All right.
Great.
Thank you so much, Mayan. Big round of applause for Mayan Bouskila, please.